I just have some objection.
Okay.
Judge, but I'm not sure which matter you want to hear first, but I believe the matter that regarding the state's motion to compel, I don't believe he needs to be here for that if you want to start with that first. We don't really have a dog in the fight with that.
Your Honor, I think that Mr. Ermine should be here.
We'll just wait. We'll wait in the abundance of caution. I know when before a judge is deaf qualified, they don't even want us like on a status just to reset it. Judge Bidwell covered all my cases till I had that class under my belt, and I'm not sure if it's the same for the attorneys, but we'll just play it safe. Better safe than sorry. Okay.
He's walking over. Yeah, he's walking over now.
Okay.
I have.
Well, this is the client one.
Oh yeah.
Attorney on the state's motion to compel answers from deponent Zachary Cruz and Richard Moore. Who's going to be arguing for the state?
I will, Your Honor.
Okay, and is Mr. Zachary Cruz and Mr. Richard Moore present?
Good morning, Your Honor. My name is Amina Matheny Willard. I am the attorney for Zachary Cruz and Richard Moore. Richard Moore is here today, but we're here prepared to argue that motion. And this is David Reiner.
Good morning, Your Honor. David Reiner, local counsel.
Okay, come on up.
Would you like us to put you at the podium?
Well, there's not really anywhere else to come to. If you want to, you can sit in the jury box if you'd be more comfortable.
Which way?
Or you can stand there, or you can. We're sort of just set up for two sides here. Okay, Mr. Klinger.
Good morning, Your Honor.
Good morning.
The state took the depositions of Zachary Cruz and Richard Moore. They were taken at separate times, about 7 weeks apart. At the first deposition of Mr. Cruz, Ms. Willard made many objections as to relevance. There was a discussion of the law in the state of Florida on relevance and how it handled the deposition. And the questions are to be answered, and later on, when the deposition or any parts that are going to be put into evidence, the trial court can rule on whether the objections made by counsel were appropriate. However, Ms. Willard continued to not only object, but she instructed her client not to answer numerous questions during the deposition. 7 weeks went by, and then there was the deposition of Richard Moore. Again, Ms. Willard was representing Mr. Moore, and the exact same thing happened. The state, once again, outlined the law in the state of Florida. The questions must be answered. The case law is very clear on that point. But once again, there were objections to relevance, and witness was instructed not to answer the question. So at this point today, we ask this court to grant the state's motion to compel. The law in the state of Florida is clear. One must answer questions at deposition unless there's privilege, or unless the party had come to the court before that and asked for the deposition to be limited in some fashion. In this case, neither of that happened, and there is no reason why both deponents should not be compelled to answer the questions. When it comes to whether or not they're used at trial, then this court can make a decision as to the
Jonathan, let me just go on.
Okay.
What I would ask the court to consider on the state's motion to compel, page 9, it references Florida Rule of Civil Procedure 1-310, subsection C, which indicates at any time during the taking of the deposition on motion of a party or of the deponent, and on showing that the examination is being conducted in bad faith or in such manner as unreasonably to annoy, embarrass, or oppress the deponent or party, or that objection and instruction to a deponent made not to answer, or being in violation of Rule 1.310, subsection C. What I'm asking the court to do is use that Florida Rule of Civil Procedure. I'd like to provide the court with a timeline so that the court understands that this deposition was not taken in a vacuum. So I think providing the court some context would be useful in this situation. Around November, and this is in reference to our response with regard to how Zachary Cruz has been treated as a result of.
I'm sorry, Mister. Give me just 1 second. It's echoing. Do you hear that?
Do we move back?
No, we just need to fix it on our end. Okay, should be better now.
Okay. So I'm providing this again to put this in context of what Zachary Cruz has gone through since this occurred, along with Richard Moore. So November 1, 2017 was the death of Linda Cruz, the mother of Zachary Cruz and Nicholas Cruz. On November 1st, 2017, the date of their mother's death, Zachary went to live with members of the family. On February 14th, 2018 was the shooting that brought us here today. On March 19, 2018, Zachary Cruz was arrested for trespass here in Broward County, and he was placed on a $500,000 bond. On May 3rd, 2018, Zachary Cruz announced that he was filing litigation against Broward County for false arrest and torture. On May 12th, 2018, the judge allowed Zachary Cruz to move to Virginia, where he is currently residing with Richard Moore and his family. On May 13, 2018, Zachary moved to Virginia. From June 2018 through the present, Zachary Cruz has been harassed and intimidated by Augusta County Adult Protective Services and the Augusta County Sheriff in Virginia. There was a local...
Counsel, I'm sorry to interrupt. I'm very familiar with the timeline. I know the facts of the case. I've read the deposition. What is or is not happening in Virginia, I don't know how that relates to his deposition here in Broward County related to an incident that happened in 2018 and the facts surrounding that incident.
Your Honor, I'll just provide the court with a summary. Basically, what is happening in Augusta County, there is coordination between Augusta County Sheriff and Broward County Sheriff. Zachary was pulled into a grand jury in the Western District of Virginia, and he was questioned about the Parkland shooting case. So we believe that there's coordination. I'm asking the court to understand that there has been consistent coordination and harassment. So we are very concerned about questions that, one of the questions is where Mike Donovan and Richard Moore were married. That's totally irrelevant. They have answered questions that are relevant to this case, but where they were married and how much is in Zachary's trust account is not relevant. So what I was asking the court what I was attempting to provide to the court is the context that these questions have come after harassment since 2017 by Zachary Cruz. So we are very leery of of Broward County's intentions as well as the coordination with Augusta County. They have no problem sitting for a deposition. They have answered questions related to what they know about the shooting, what they know about Nicholas Cruz. All of Richard Moore's conversations with Nicholas Cruz are recorded. The state has that. Richard Moore has readily admitted that he has a criminal record. He has asked the state to provide that criminal record so he can give the details that the state essentially already has. But I just want the court to understand that this is not happening in a vacuum. Zachary Cruz has been harassed since 2017, and the questions that were purported to be for this hearing had absolutely nothing to do with why we're here today. So again, we don't have any problems answering the questions. We can provide them in written form so the court can determine the relevance. We can offer that the court provide a magistrate judge to sit in on the depositions. But the bottom line is we want the court to understand that we feel this is continued harassment by Broward County, and it is tantamount to witness tampering. The state knows what Zachary Cruz's testimony is going to be, and essentially it's going to be the fact that it appears that Broward County ignored all of the signs leading up to the shooting with regard to Nicholas Cruz.
That's going to be your client's testimony?
Some of it, yes.
Well, that is interesting because I've already ruled that that's not admissible. So I'm not sure where you're getting that information from. But third-party negligence has already been ruled to be not admissible in this case. So I think that you might be perhaps confused on the issues or why your client is being listed as a witness or why the state feels that they need to get into some of these areas. Is there anything else?
Your Honor, just that again, we feel that this is continued harassment. Certainly Zachary Cruz has a number of other things that could be offered to the jury, maybe not necessarily regarding the third-party negligence, but it certainly could be surmised by a jury that that's part of the situation. So again, we have no problems answering the questions with regard to the criminal record of Richard Moore. He simply asked for a copy of it so that he can verify his record and not fall into a perjury trap. But we do want the court to know that we feel that this is continuing harassment. We're also asking the court to investigate based on all of the information it has, and ask the Florida Department of Law Enforcement to investigate.
Investigate what?
Your Honor, as I indicated before, we feel that this is tantamount to witness tampering.
Asking a witness questions like, have you ever been arrested? Are you married? Where do you live? I read both the depositions in full last night and highlighted. You're saying there's continued harassment that would warrant the Florida Department of Law Enforcement getting involved? That's
Absolutely.
a big accusation, which if you feel that's the case, then you, ma'am, by all means, should be contacting the police yourself to report this incident.
Your Honor,
rather than wait and put it on me in court. That's not my job. But if you're a citizen and you're traveling to Florida and you represent a client that perhaps lived in Florida at one time, if you think a crime's been committed, then by all means you should report that. But to come to court and ask me to, I guess, impanel a grand jury and open up an FDLE investigation into what I believe are entirely appropriate questions that were asked at deposition, that seems a bit far-fetched.
Your Honor, I can tell the court that we have reported this to a law enforcement agency and FBI in Virginia, not here in Broward County, but again, the types of questions that are being asked are completely irrelevant to this sentencing here today. But again, that is our contention, and how much money Zachary Cruz has in his trust account, that's one of the questions of many that we feel are extremely irrelevant and constitute harassment.
I disagree. We've had hearings on the finances of the defendant, probably 2-3 days of evidentiary hearings to determine whether or not he qualifies for a public defender. That issue could conceivably come up at another time or on appeal, and there were documents that were given to me early on in the case showing that the two young men shared bank accounts with their mother. So those questions are entirely relevant, and even if they're not admissible at trial, they could lead to other relevant information.
Your Honor, and I do understand the finance of Nicholas Cruz. Zachary Cruz, we've advised the state that his accounts are separate. So we don't feel that they would be relevant. But again, we don't mind sitting. We would ask the court to appoint a magistrate in order to monitor, to make sure that the questions are appropriate from the state, or we would ask the court to allow us to submit the answers in writing so that the court can review the relevancy of the responses.
Okay, State, is there anything else?
I would just again point out to the court that the court has already indicated, the court has read the depositions, the questions were all relevant. Counsel, it's amazing the counsel comes in here today and makes this argument when she could have come in here months ago and made that argument under Florida Rule of Civil Procedure 1.310D. She never bothered to come in until today to make the argument. All those questions were relevant and they were based on facts that could possibly be biased or whatever the state needed to find out from the two witnesses, and I'd ask the court to grant the state's motion to compel.
Your Honor, just in response to that, we were hoping that the state would abandon the motion to compel. They have not, which is why we were here, but we were not going to preempt their opportunity to abandon this request.
Okay, based upon my review of the evidence, the depositions as well as the arguments of counsel, I do find that all of the questions that were asked to deponent Zachary Cruz and deponent Richard Moore were not only appropriate, but questions that may lead to relevant information pertaining to this case. I find that the questions were asked in a regular, methodical manner. There was no harassment or any kind of malfeasance that I could read based upon the way the questions were asked and the sensitivity in which many of them were asked when it came to the subject of the deponent's deceased mother. Based upon that, I am going to grant the state's motion. I am going to order that both deponents appear for deposition, that they answer each and every question, that are posed by the state unless there is a question of privilege. I did not see any allegation that the questions were not being answered because of some type of privilege. Counsel, I don't know if you're aware of this, but in Florida, when a person is served with a state subpoena, that comes with use immunity, and they cannot be prosecuted for anything that they say other than a lie. So,
Your Honor, in response, they can be prosecuted federally. So that they can be prosecuted by the federal agents or by Augusta. So I understand what you're saying with regard to Florida, but they can be prosecuted federally. So that's...
Well, as far as I know, there's no Florida or federal law that says that if you've been arrested for a crime and you admit that in a deposition, that you can later be prosecuted for that.
Well, he asked about use of marijuana. Use of marijuana is still illegal federally. So I objected to that question because I didn't want Zachary to answer that question. So that's an example of where that is coming from.
Counsel, the feds are not going to prosecute somebody for admitting in a deposition that they used marijuana. First of all, being under the influence of marijuana. And there was a distinction. It wasn't smoking marijuana, it was under the influence of marijuana. That's not a crime.
Zachary has been through a lot. He's been through a lot that we would not have expected him to be through. So he was, again, hauled into a grand jury in Virginia to ask questions about a Florida case. So I'm not entirely confident that the FBI is not going to use those questions against him, even if it's about marijuana. He had $500,000 bond on a trespass. So again, respectfully, I'm just letting the court know that there are some issues federally.
Okay, well, he's going to answer all of the questions. If he doesn't, the remedy is going to be that I'm going to strike his testimony. Like I said, I have reviewed all of the questions that were asked by the state. They were all relevant, appropriate questions, and under Florida law, both of the deponents are required to answer. If you want to certify a question, that's fine, but the deponent still needs to answer the question, and then you can bring it before me. However, instructing a deponent not to answer a question is inappropriate, and it is not legal under the Florida Rules of Procedure, unless there's a privilege, and there was no privilege that was claimed. So that's my ruling.
Understood, Your Honor.
All right.
They will comply.
Thank you, Judge.
Your Honor, we would like to schedule that deposition now. Trial is commencing again on Monday. I'd ask we're available tomorrow if counsel can produce her clients tomorrow.
I cannot produce them tomorrow, but I can produce them.
How about today? Because really, they should have been here today.
If the court would allow me about 10 minutes.
Sure.
And as long as you're okay with what I'm doing, if I Zoom.
That's fine.
Thank you.
Thanks, Your Honor.
Okay, what's next?
Mr. Secretary, ready on this ground?
Yes, sir.
Where's Mr. Secor? You were going to give me a transcript.
Oh, yeah, I forgot. I can email it to you right now, if that'll work.
Sure. Mm-hmm. message. Keep He's supposed to be a super speller. You have it? Wait, P-R-I-V-I-L.
Judge, it should be in your inbox.
Thank you.
Yes, ma'am. Sorry about that.
No, that's okay. Okay. I have the deposition of, no, I don't, Finay Broward, is that how you say the lady's name?
Yes, ma'am.
Your Honor, if I, since the first objections are mine, if I may start.
Sure.
First of all, I think I'm from pages 5 through 7, line 21. I don't think they're on the video anyway, so those would be struck. Correct, Mr. Secor? Sorry.
5 through 7, is that right?
Yeah. I think we would begin on page 7, line 22.
Yes, sir.
Okay.
So I guess we're just agreeing to redact everything up until page 7, line 22.
Correct.
Okay.
I believe the state's first objection is on page 30, line 5, and the state would withdraw that objection if you could delete page 30, lines 5 through 15.
Mr. Marcus, I'm not following you.
Page 30.
Right.
The state objects on line 5, and the state is going to withdraw that objection. And there's just talk between lines 5 and 14.
Oh, I see. So the objection that you made during the deposition, you're withdrawing,
Yes.
but you don't think that the banter between you and Mr. Secor should be reflected in the deposition presentation to the jury.
Correct.
So, Mr. Secor, is there any objection to redacting page 30, line 5 through and including page 30, line 14?
Hang on just 1 second. I'm sorry, line 30.
Page 30?
Page 30, line.
Line 5, where it says, Mr. Marcus, objection. I'm going to object at this point as hearsay. And then the two of you have some conversation.
Right.
Up until, excuse me, line 14, Mr. Secor, where you say, okay, thank you.
Yes, ma'am, that's fine, thank you.
Okay, so that by agreement is granted. Page 30, line 5 through page 30, line 14 will be redacted.
on page 31, lines 10 and 11, it doesn't seem to be important anymore because Mr. Secor just restated the question, and I objected on line 17, and I'm going to withdraw the state's objection on page 31, lines 17 and 18.
What about line 10 and 11?
Well, he restated the question.
Okay.
So, Mr. Secor, if you want to delete the question from 6 to 11 or leave it all in there, it doesn't matter to me. I'm not objecting on the hearsay any longer.
Okay. Yeah, I mean, if we're going to redact, I guess we should do line 6 through 18. But
It doesn't seem to me that there's any harm to either party to just leave that in.
I agree.
It's just a natural course of
That's fine.
questioning a witness, seems.
Yes, ma'am.
Okay, so that's page 31. And what was the next section that you said, Mr. Marcus, line 17, you're withdrawing that objection?
Yes.
So, how would you like to handle that?
I'm happy to withdraw it. If they can delete it, that's fine with me.
All right, so page 31, lines 17 through 18 will be redacted. State withdrawing objection.
Thank you, Your Honor. I believe the next objection will be on page 57. Actually, it's not an objection, it's just, it's an interruption in the case.
Let me get to 57. You said 57 line, where the witness takes a call?
Yes, I just recommend that be deleted so it just doesn't interrupt the testimony.
Okay, Mr. Secor, is there any objection? Mr. Secor, okay, you pronounce your name Secor, right?
I do, but whatever.
But everybody's been saying Secor, so now I started wondering if I'm pronouncing it right. It's Secor.
I mean, I say it's Secor, but...
So it's like Secor, like S-E-E, and then core. That's how you would... Okay. Secor.
Again, I really don't...
No, it's important to me to get it right. So, Mr. Secor, do you have any objection to redacting page 57, line 9, where it says phone ringing, through and including line 18, where the reporter says we're back on video record at 11:40?
No objection, no.
Okay, what's next?
Your Honor, on page 58, the state's going to withdraw its objection as to relevance on lines 9 through 10.
Okay.
As they be deleted. Or actually 9 through 12.
That's fine, Your Honor.
Okay. So page 58, lines 9 through 12 will be redacted as state is withdrawing objection.
Likewise, on line 22, the state will withdraw that objection. Delete line 22.
Okay.
Your page 60, the state would withdraw its objection on line 7 through 14, those lines.
Did the witness say he's objection leading? He says you're leading?
Yes.
That's funny.
Turns out you were right.
Okay. So what do you want?
Delete 7 through 14. It's just not necessary.
Okay, Mr. Secor, any objection?
No, ma'am.
All right. Page 60, lines 7 through 14.
And also 20 through 21, lines 20 through 21 on that same page. Page 60. I'm withdrawing the objection.
So, Mr. Marcus is withdrawing his objection, so lines 20 through 22 will be redacted. Is that what you're asking for, Mr. Marcus?
Yes.
And Mr. Secor, are you in agreement with that?
Yes, ma'am. Let me just bring up one thing here.
Sure.
On the bottom of page 59, there was another objection by Mr. Marcus that's vagueness. I just want to make sure that in the event that Mr. Marcus wanted to address that he didn't skip it.
Thank you. We can do this. Actually, it was corrected. That's why I skipped it.
Okay.
You just said, I think that could just...
You're right. I agree that it's correct. His objection was correct, so we can just leave it.
Okay, so then that's nothing else to the bottom of page 59.
Next objection is at page 84, Your Honor. And I think, like the last one, I don't think it needs anything to be done. It was just restated and cleared up in the next question.
What line are you on?
On page 84, lines 24, 25, going on to the next page, 85. And then Mr. Secor restated it, so I think it just cured itself.
Okay. Are you in agreement, Mr. Secor?
Yes, ma'am.
Next objection, page 86, line 22. The state would withdraw the objection as to leading.
So are you asking that just line 22 be taken out?
Yes.
Okay, so that's page 86. Line 22. Counsel, do you want to come on up? I want to take the motion to compel in the. Don't tell me I wrote it down. Miss Matheny Willard.
Yes.
I'm going to take you so that you don't have to wait.
Judge, if I may, I'm sorry. I'm speaking to all of the team members. We're not available today or tomorrow. What we would propose, Your Honor,
But we were supposed to be in court, so why wouldn't you be
because
available?
we've set up, we have witness meetings, we have other things we're getting ready for Monday. None of us are available after court this morning.
May I ask?
How do you know how long I was going to take?
What, the deposition?
How do you know how long I was going to take in court?
After court, Your Honor. Maybe not this morning, it could be later this afternoon, but we aren't available.
May I inquire of the defense as to what their plans are for calling these two witnesses?
I don't know what you mean by plans. What I can tell you, What I can tell you, I can't tell you that. What I can tell the state and Your Honor is that the defense will not mention anything outside of any depositions that have already been conducted. The information that was provided for those depositions that have already been conducted in any form until you have an opportunity, if I may.
I don't understand. I'm not following you.
So what I'm saying is for opening statements, we're not going to bring up information that hasn't been discovered by the state.
The thing is that they have a right to finish these depositions.
Right.
How many more questions do you have? How many more questions do you have? Are there a lot?
No. I don't think it'll, if the answers are forthcoming, it should not be that long.
I mean, when you say not too long, do you say, is that like 15 minutes?
I'm thinking there was about 30 questions each.
Left?
Somewhere in that range. They were attached to the motion to compel, so approximately that number.
So, do you think an hour would be sufficient for both witnesses?
I would say an hour each, perhaps.
What I was going to propose, Judge, is the week of Labor Day, we have that September 6th day that is to be determined. It would have been the only day we would be in trial that week. I was going to recommend maybe using that day to take the deposition because we just aren't available today or tomorrow.
And you think your case is going to go all the way through to September 6th without any gaps before you call these witnesses?
When you say gaps, any mention of?
No, I mean, you have enough witness testimony to start on August 22nd and go through and including September 6th without having to stop and take a break for these witnesses?
Yes, you do. At least tentatively. I mean, trial's fluid, but yes.
Okay, do you want to do it September 6th?
As long as they're representing, they're not going to be calling these witnesses before that.
Counsel, does that work for you, September? Sorry, I made you go. I thought that this could be done right now. I had forgotten that the defense has a right to be there too.
Yeah, I'm going to make it work.
Okay. Do you all need to exchange information or anything like that, or you can take care of that after court?
After court, we have it.
September 6th works for both clients?
Yes.
We can work other times later then.
Yes.
Okay, thank you.
Thank you, Ron. Thanks, Ron.
Thank you. Okay, going back to the perpetuated testimony of Finney Browd, we're on page 86. The last line that we had discussed was line 22 being redacted because Mr. Marcus is withdrawing that objection.
Your Honor, I did ask the court yesterday, or did indicate to the court that it probably wasn't necessary for you to read everything. As you can see, we're skipping through quite a bit of the testimony. I would ask the court to just read pages 96 and 97. That will become relevant in subsequent objections that you're going to hear from. So instead of going back and forth, if you could just read 96 and 97.
No problem. Just give me a few minutes. 96 through 98.
Thank you, Your Honor. Now, on page 98, lines 4 through 13, there's no objection, but I'd recommend deleting that as right stuff.
Page 98.
Yes, lines 4 through 13.
Mr. Secor, any objection? Is there any objection to removing page 98, lines 4 through lines, I guess, 16 or 17?
No, ma'am.
On page 21, the state may...
Page 21?
I'm sorry, page 101.
101, that's okay.
The state is maintaining this objection. The witness was asked about her adopted son and how that gave her insight into Nicholas eventually. The court may want to read from page 101 through 104, the end of the cross-examination. There's a series of objections where the witness is asked to give her opinion as to the diagnosis of Mr. Cruz, and she gives a diagnosis of autism. She's not an expert. There's no testimony that she's an expert other than she had a child who had problems.
Well, let me first ask this. Mr. Secor, do you disagree?
Yes, ma'am, I do.
Okay, then let me go ahead and read the few pages, and then I'll let you know when I'm finished.
Thank you.
At the subject matter that we're discussing ends on about halfway down page 102. Is that correct?
Yes, Your Honor.
Okay, so I've had the opportunity to read 101 and 102, and the first objection begins on page 101, line 18. And then there's a second objection on 102, line 12. Okay, so Mr. Marcus has indicated he believes this is not relevant and therefore not admissible because it's an opinion being given by a layperson. And Mr. Secor, you believe it is relevant and admissible because?
Yes, ma'am. Thank you. First of all, I would argue that Ms. Brown, when she's referencing autism spectrum disorder, she's talking about her son, not about Nicholas. Because she's comparing what she saw in Nicholas as a child and what she experienced with her own son when he was of a similar age as Nicholas was during the time that she was thinking about him. And it's relevant and probative for purposes of the mitigation presentation because the state's argument is going to be that Nicholas does not have a developmental disorder. Ms. Brown's son does have a developmental disorder, and he went through a great deal of, or the family went through a great deal of trouble trying to get him help for that disorder. And her observations of Nicholas when Nicholas was young, as compared to her observations of her own son, would substantiate our mitigation presentation about Nicholas. She's not rendering an opinion about his diagnosis. Of course, she's not an expert. It's a lay opinion, similar to if somebody said, I saw a car traveling fast. She's talking about the way that Nicholas behaved as a child, and he had uncontrollable tantrums and couldn't be reined in by his mother. And so we would argue that it goes specifically to Nicholas's character and background. And for purposes of my argument, I just want to make a couple citations. First of all, Florida Statutes 921.141, Section 1, as Your Honor obviously is aware, states evidence may be presented as to any matter that the court deems relevant to the nature of the crime and the character of the defendant, and shall include matters relating to any of the aggravating factors or mitigating circumstances. Any such evidence that the court deems to have probative value may be received, regardless of its admissibility under the exclusionary rules of evidence. And I would just cite Barber v. State, 4 Southern 3rd, 9 Florida 5th District Court of Appeals 2009, and Johnson v. State, 660 Southern 2nd 637, Florida Supreme Court 1995, for the proposition that the rules of evidence are relaxed at the penalty phase of a capital case, and that for purposes of just federalizing my argument, Tenard versus Dretke, 542 U.S. 274, 2004, Payne versus Tennessee, 501 U.S. 808, Eddings versus Oklahoma, 455 U.S. 104, and Lockett versus Ohio, 438 U.S. 586, for the sort of combined proposition that's be a violation of the due process clause of the 14th Amendment for a trial court to bar admission of relevant mitigating evidence. And I would just state in conclusion that obviously relevant mitigating evidence is evidence which tends to logically prove or disprove some fact or circumstance which a fact finder could reasonably deem to have mitigating value. And I think that the issue of Nicholas having a developmental disorder is certainly going to be one that is in dispute, and so therefore Ms. Brown's testimony would be specifically relevant to whether or not he has a developmental disorder. And also, it is certainly, if the jury believes he has a developmental disorder, it is certainly something that a juror could individually find is worthy of a sentence of life without the possibility of parole. Because a person could say, well, somebody who commits 17 murders and does not have a disorder, I'm probably going to give them the death penalty. But if I think they have a developmental disorder, then I might lean towards life without parole. And so I do think it's highly relevant and probative of that issue in this case, and certainly is the type of mitigating evidence that is I think, anticipated and expected to be presented to juries and should not be restricted in any way. Thank you.
Your Honor, just some quick rebuttal. First of all, Ms. Brown does testify as to his behavior, so the defense has been able to get out his behaviors, which are probably a predicate for expert witnesses to testify. If you accept the defense argument that she was talking about her own son when she talked about autism spectrum, then it does not relate to the defendant's background, character, or circumstances of the offense. She's talking about her son, so there's nothing relevant about her son's condition. And that's the reason why the state objected. And I'd also like to point out, and the court may recall when Sergeant Navarro, the JROTC instructor, testified.
He was an Army sergeant, not a sergeant with the police department.
Correct.
But you called him sergeant, I think.
He was a sergeant in the Army.
In the military?
Military.
Oh, okay.
Military.
Okay. I just want to make sure I'm thinking of the right person.
Correct. You may recall that this was, there was cross-examination by Ms. Basherman, and a question that she asked at that time was, and it's from page 5862 of the record, the question was, you were aware from his cadet data sheet, which you get for all the students in JROTC, correct, that his mother had stated he was low and autistic, and his answer was yes. The defense obviously wants to bring out any evidence that he was autistic, and that may be fine, but in terms of this particular witness, this has to do with her son, according to what Mr. Secor said today. The state doesn't believe that that's what her testimony was. Her testimony was that they both had autism, and she could tell from her own son. And to that extent, she's not an expert, can't give her opinion, but if you take Mr. Secor's argument, then it's completely irrelevant because she was talking about someone else, not the defendant.
If I may just briefly, Your Honor, it's not our position that Nicholas has autism spectrum disorder. There is, however, a great deal of overlap between autism spectrum disorder and fetal alcohol spectrum disorder. They're both neurodevelopmental disorders.
I think we might be getting off sort of on a tangent here. I think the issue is whether it's relevant and whether a lay witness can testify as to an opinion about a diagnosis. That's really what I'm narrowing in on.
Okay.
And I didn't mean to cut you off, but I just think we're sort of we're branching out into other issues that I'm not sure need to be discussed at this time. But my perception is that the fact that the witness has perceived her own child exhibiting certain behaviors, and because of those perceptions and her ability to observe her own child and then recognize similar behaviors in another child, I think that is relevant and admissible. However, her statements about the autism spectrum and learning disabilities, I think those are improper opinions of a lay witness. I also think that it is not relevant, and I'm sure, you may have asked us to be nice. You said, have you been able to get your son any help? And she says, my son, oh yeah. That part, although it was nice of you to ask, I don't think is relevant to this particular witness in this trial. So, based upon that, do you want me to tell you what I believe needs to be redacted? And unless either side wants to add anything after what I've explained are my perceptions of this part of the deposition.
The only thing I would add just briefly regarding the question about has Ms. Brown been able to get her son help, and I appreciate the court saying that was me being kind, and I wish I could say that it was just me being kind.
Okay.
I actually had a different agenda that will arise later in the transcript. I just wanted to tell you that because I do think it's relevant, but I don't mind you removing that one particular line from this portion, but I just didn't want to abandon the argument for purposes of later in the transcript, actually.
Okay, so beginning on So, lawyers, let me ask you this. I've only done perpetuated testimony maybe once or twice. If I overrule an objection Does the objection stay in there? Does it get redacted? Do I say overruled when the testimony is being perpetuated or played to the jury?
Well, you can delete it, what you like.
Okay.
And
Okay, that's fine. So we're going to delete Mr. Marcus's objection, starting on page 101, lines 18 through and including Mr. Secor, line 25. So page 101, line 18 through 25 will be redacted. And so it'll go from page 101, question, and can you tell me what you meant by that? And then the answer on page 102, okay, I noticed the aggressiveness in my adopted son, and so on and so forth. The line 4 on page 102, the learning disabilities, the same as Nicholas. I believe that's an improper opinion by a layperson, so that should be redacted. And then on page 102, starting the second half of line 7, and I think, are you all with me?
yes.
And I think, line 8, that's, well, I learned later on that he has, that has to do with the autism spectrum, That will come out. And then also lines 10 and 11. Have you been able to get him help? My son, oh yeah. And then also Mr. Marcus's objection, irrelevant, will come out as well.
Your Honor, can I just make sure that I'm absolutely clear?
Yes, and I'm marking. I actually printed a copy that I'm marking
Okay.
so that after this, we can check to make sure everybody has the same
Yeah, that's great.
records if you want, because I know this is a little bit.
And on top of page 102, just want to be clear, are you allowing that whole first paragraph on page 102 up until the words, and I think that's,
No.
Except for the sentence it says on line 4, the learning disability is the same as Nicholas. That should come out. So it would read, okay, I noticed the aggressiveness in my adopted son. I noticed the tantrums in my adopted son. Same kind of tantrums like Nicholas was having. A lot of things in comparison were the same, actions, and like my son couldn't verbalize himself either, that type of thing.
Thank you very much.
Sure, and then the rest will come out, and then we'll start back on line 14.
I just respectfully ask that you note my objections regarding those redactions. Although I'm totally fine with you taking out, have you been able to get him help, my son, oh yeah, for purposes of this portion. Thank you.
Okay.
Your Honor.
Yes.
The next portion would just be to clean up the video from lines on page 103, lines 22 to 25, and the next page 104, lines 1 through 14, in the cross-examination.
Okay, so on page 103, lines 22, where Mr. Secor says, Mr. Marcus, I believe that's all I've got now. How do you feel about a lunch break? Mr. Secor, is there any objection to redacting that part, which is lines 22 through 25 on page 103?
No, ma'am.
And then, Mr. Marcus, you said on page 104, that's more about lunch.
Yes. Line.
Okay, so basically, all of the top of page 104. Page 104 will begin line 18 by Mr. Marcus. Hi, Miss Broward. Is there any objection?
No, ma'am.
I don't believe there's any objections up through at least through page 135. I was going to suggest there's a break again from lines 15 through 24 on page 135 to be deleted.
Okay, Mr. Secor, is there any objection on page 135 to deleting line 21 where the reporter says we're going off the record through and including we're back on the video record at 2:40 p.m.?
No, I think Mr. Marcus was talking to a little bit above what Your Honor was just saying.
Okay, sorry about that. Oh, you're right.
Maybe starting at line 15, I think.
Line 15. Can we just take a break for a minute?
Yes.
Okay. So lines 15 through 25 on page 135.
That's fine, Your Honor.
And then it should start back up on page 136 by Mr. Marcus.
Yes, Your Honor.
Okay.
I think the next consideration is page 147.
Yeah, I'm gonna ask Your Honor actually to, there's a large section I'm going to ask that I'm going to try to condense into a single argument. It begins on page 140 and goes to page 156.
Do you want me to just read it?
Yeah, or I can give you a brief synopsis if you want first, and then you can read it if you think that you need to. But we may be able to find some common ground on it. These questions that are asked of Mr. Marcus from pages 140, starting on line 22 through page 156, line 25. This is a series of questions that Mr. Marcus asked Ms. Brown that pertain to the Vineland questions that we had a hearing about that Your Honor ruled on. And so these are the same types of questions that Mr. Marcus asked in the deposition. And the reason why I'm bringing it to the court's attention now is that those Vineland assessments that were done by Dr. Brown in this case, we were challenging the state asking those same questions of Ms. Brown as a way to impeach Dr. Brown or somehow call into question the legitimacy of those Vinelands. We are no longer using those Vinelands created by Dr. Brown. And so my argument would be that there is no relevancy in the state asking her being Ms. Brown, those questions, because my understanding is that he was asking them for purposes of attacking the Vinelands that this defense had been relying on, but I'm stating for the record now that we are no longer relying on those.
Okay.
Do we have a moment, please?
Yes.
This is entirely new news to us.
Okay, let's take a 5-minute recess anyway. I need a quick recess. Okay, and then I'll read 140 to 156.
you read this, looking at it, whether or not they're even necessary any longer. And so we would like to table this question until, I guess tomorrow we'll figure out what we're going,
Okay.
and our position will be about that.
Okay, so I'm just going to clip this. It's 140 to 156, right?
Yes, ma'am. I would specifically say page 140, line 22 through page 156, line 25.
All right, I'm just gonna.
140, line 22 through what?
156 at line 25.
If we can proceed then to, I believe the next objection is page 160.
Yeah, I have another sort of large swath of the transcript that I'm going to object to, and the entirety of it is going to be from 157, line 10, through 174, line 11. And I have, again, I'll try to condense my argument for that whole section to the following.
Okay, would you just give me 1 second, please?
Yes, ma'am.
Okay, go ahead.
And what starts on page 157, line 10 is Mr. Marcus asking about psychiatrist or psychologist that the defendant was seeing. And Ms. Browd says that Nicholas was seeing, no. And then Mr. Marcus says, okay, I'm just going to go through some names I just want to verify, okay? And from that point forward, all the way through page 174, is a bunch of questions to Ms. Browd about whether or not Nick was seeing therapists during the time frame when she tells Mr. Marcus repeatedly she has no knowledge of that time frame.
Mr. Secor, can I just a clarification?
Yes, sir.
So that argument he made may be true, but it's not true on page 157. That is, I did ask about a period of time when she said she knew him. So I think on page 157, for example, I'm talking about 5 years, 8 months old. Were you aware of a psychological evaluation?
What page are you on?
Page 157, line 13. Dr. Kravitz, 2007, 2008. Those are time periods when she knew him.
Yeah, no, you're right. For that first paragraph, you are right. And she says she wasn't aware, but what happened? Miss Browd and Mrs. Cruz, they had a falling out. They were very close friends, but they had a falling out that began in around 2008. The last time they ever saw each other was in September of 2010, but they had limited contact between 2008 and 2010. And a great deal of the questions that Mr. Marcus asked Ms. Browd about are subsequent to 2010. And she tells him, I didn't know anything about that time frame. And he continues to ask her, which, in deposition, he was entitled to do for purposes of investigation. But she tells him repeatedly that she didn't know. She doesn't know the things that he's referring to. And a couple of times even says, as I told you, I didn't know anything after 2010, which she says specifically on page 163. She actually says to Mr. Marcus, as I explained before, I don't know anything after 2010. I don't know what counseling he had, what kind of therapy he had, or any diagnosis that was made at that point. And then subsequent to that, Mr. Marcus goes into asking her about school records and whether Ms. Browd was aware of things that were in Nick's school records. And the school records he's referring to are from West Glades Middle School, which Nick didn't start attending until 2010, which Ms. Brown never had any contact with Nicholas after 2010. So all those questions, again, are about a time frame she doesn't know anything about, and she tells Mr. Marcus she doesn't know anything about those. They include references to swastikas, which is obviously still subject of a pending motion. There is also a reference to drawings taken from Nick's cell at the jail, and those are shown to Ms. Brown, and she says, I don't know anything about that. She also says the same thing when she's shown records from West Glades Middle School. I don't know anything about that. Again, she didn't know anything about Nick, never had any contact with him, never spoke to him after September of 2010. And so my argument that we should redact, or that Your Honor should order redacted pages 157, line 10 through page 174, line 11, is that these questions lack relevance, because she said she had no knowledge of that time frame other than the very beginning, as Mr. Marcus correctly pointed out, when she did know him during the first few years that Mr. Marcus referenced. I would also argue that asking her all these questions is hearsay because he is presenting her with information from third parties and she's saying she doesn't know anything about it. I would also argue that Mr. Marcus was arguing himself through the deposition by asking her questions, even though she kept saying I didn't know anything about that time frame, but he kept presenting this information. And at one point on page 168, she reiterated that she didn't know, and Mr. Marcus said, quote, I understand, I just want to make this on the record, which I interpreted as him wanting to make sure that this information was in the record, but that certainly would not be a proper grounds of cross-examination in front of a jury to just say, well, I want to make sure this information is in the record. So I would argue that it is hearsay, and it would be improper impeachment because she doesn't know anything about this, which she repeated over and over again. But it would be also presenting facts not in evidence because none of the things from the school records or from Nick's cell or any of the photographs that he also showed her photographs taken by law enforcement of the rifle, magazine, and boots that were recovered on the day of the incident. She said obviously she didn't know anything about those things. And I would argue that it's an attempt to present non-statutory aggravation through a mitigating witness, and that it wouldn't pertain at all to the content of Ms. Brown's direct, because I, of course, didn't ask her about any of those things, and would therefore exceed the scope of what the direct was about. But primarily, my most concerning argument is that it's presenting non-statutory aggravation through a mitigating witness, which is obviously evidence that the jury can't rely on. Thank you.
Thank you.
First of all, Mr. Secor didn't make an objection until page 160. This was the perpetuated deposition. I don't think he can now make objections that he didn't make before. He finally made that objection at page 160, is my first point. I asked the court to read 96 and 97 as we were coming up to those pages, and this is the reason I asked the court to read those pages. Ms. Browd is portrayed by the defense in direct examination as an expert on Nicholas Cruz at ages up to approximately 12 years of age. She also holds herself out, I don't mean this literally, but as an expert on Linda Cruz, and that she knows Linda Cruz very well, and she testifies all about Linda Cruz as well. And on page 96, this is direct examination. In 97, she testifies that Linda Cruz never went the extra mile to take him to therapy or, get a diagnosis. And she says, I used to push her to do things. I was like her voice because she wasn't an aggressive person. She would listen to people talk in her ear type thing, and she would think they were giving her the right advice because it sounded good to her, but it wasn't always the best advice. I'm reading on page 96 of the transcript. She wasn't aggressive when it came to like finding things out, going the extra mile, you know. If she called somebody and they told her something, she would believe them. She wouldn't do the research, you know, that maybe they're not telling her the truth or the whole truth or whatever it is or whatever the situation was, okay? Like the school with Nicholas, okay? When he was in Coral Springs and he was in that program, she's referring to elementary program, that my son also was in the same program later on. Okay, she would just go with the flow of whatever they tell her in these meetings and stuff like that. But she never went the extra mile to like take him to therapy, or at that time, okay, take him to therapy, or, you know, get a diagnosis, you know, have him tested, that type thing. Have Nicholas tested or anything like that, because she didn't know any better. She would believe whatever you told her, especially if you're in the school, you're an authority, she believes what you tell her. So, Your Honor, this is cross-examination, and that is what I am doing. I am cross-examining her as to her knowledge of Linda Cruz. And beginning as Mr. Secor pointed out, page 157, line 10, I asked her what she really knows about what kind of help Linda Cruz was giving to her own son. And Your Honor, this is in rebuttal of mitigation that her mother was ineffective. This is what is being brought up, that that the defendant had an ineffective adopted mother, Linda Cruz. And so what I'm pointing out after what is brought out in direct examination was, were you aware of any psychiatrists or psychologists that the defendant was seeing? And as we begin here, I don't think the defense is going to contend that this isn't true, and we would be prepared to prove this in rebuttal if the defense does not agree to it. But she was getting him psychological testing when as early as 5 years, 8 months old. And Ms. Brown was unaware of that. If she was so knowledgeable of Nick Cruz, she would know about this. He was going to see Dr. Kravitz from 2000 to 2008. Those are times that if she knew him well, which she said she knew him during that time, but she was unaware of it. She was unaware of a psychiatrist, Dr. Karp, from 2008 to 2011. Most of that time were times that when she should have known it according to her own timeline. And then there was Henderson Behavioral Health. She wasn't aware of this, except she was aware one time she saw a therapist coming to the house, just one time. And literally, there were over 100 times that therapists would come to the house from Henderson to give him in-home therapy. So this shows that Ms. Brown is not an effective witness. This is impeaching her credibility of knowing about, actually knowing Mr. Cruz's early life. She overstates her knowledge of Mr. Cruz. All the counseling that he received after that, West Glades Middle School, it doesn't matter if this happens after she knows that the breakup between her and Miss Cruz. This goes to now, was Miss Cruz an effective parent? And she's unaware of all the things that Miss Cruz did, all the therapies that she made sure he had, the ESE, individual education plans, exceptional student education that he was getting in the schools. She's saying she won't go the extra mile. I'm saying through cross-examination that she went, 1,000 miles for her son. And so Miss Brown is impeached by her lack of knowledge of everything that Ms. Cruz provided for him. I think we can move into, there's the other objections as to...
Before we go there, okay, so this is what I want to do. I want to read this whole deposition.
Okay.
I think it would help me, but I want to page mark the pages in contention. And Mr. Secor, you originally said 157 to 174, but as far as I can tell, the line of questioning goes on through at least 177, if I'm not mistaken.
Okay.
So I just want to make sure I know your specific objections. I understand the line of questioning you're objecting to. I understand the state's response as to why they feel it's an appropriate line of cross-examination, but so that I can rule later on this afternoon, once I read it in its entirety, I want to make sure I know exactly what you're objecting to when it starts and when it ends.
Yes, ma'am. And I will, based on what Mr. Marcus said, I will move the time frame of my objection to begin page 158, line 10. That's where I believe that the redaction should begin, because he's right. The first couple of questions that he asked were during a time frame, at least partially, when Ms. Brown was still in communication.
Okay, so let me just, so your objection begins, just to be clear, on page 158,
Yes, ma'am.
line, what line?
10.
Line 10.
Yes, ma'am.
Page 158, line 10, through, and can you tell me if I was correct?
Yes, ma'am. Let me
Just give me a second, I don't know what I did here. 158, line 10 through, you had said 174, but I just want to make sure that's correct.
Yes, ma'am. I'm just trying to verify.
Okay.
That I didn't miss anything. Thank you.
Your Honor, if I may just go on just a little bit further.
Sure.
Because if the court is going to be reading the rest of the deposition, I'd like the court to just have the benefit of why the state was continuing to ask these questions. At one point on page 177, Ms. Brown is asked on line 13, are you now aware, after I go through everything that she did for him, and then all the things that he was doing in terms of problems he was getting into school, things that she wasn't aware of, damaging the house, damaging furniture, I asked her, are you now aware that despite all the help Linda Cruz got, the defendant's behavior remained out of control? And this is a very important answer. Her answer is yes, I'm aware of that now. So this shows that she was completely unaware of everything about Nicholas Cruz. To be an expert on him and Linda Cruz, she's admitting she was totally unaware of all of that, but now she is aware. And I continued to educate her as to the conduct of the defendant, including through the shooting, the swastikas, and through his misbehavior in the jail, which the court may recall from Dr. Brannon's testimony when this was relevant to the swastika pretrial hearing, where Dr. Brannon's testimony was why that information was relevant to the diagnosis of antisocial personality,
right,
and to rebut the mitigation. And in this case, what we're at now is the defense has introduced, as you recall I read, the autism cross-examination by Ms. Bashman, Sergeant Navarro. They have opened the door to the defendant's mental health. Now, they've made it clear that they intend to kick that door open even more, but they've already introduced it, and I understand we're looking at this now in terms of where we're at this moment. But the defense at this moment has already opened the door to his mental health testimony by asserting that he had autism, asserting the mom's belief that, and Sergeant Navarro confirmed that she said he had autism. We are able to rebut that defense with his antisocial behaviors, which includes all the awful things that he did, including the swastika, all the writings he did with swastikas, the gun. This is part of his antisocial personality that we should be able to rebut. But the point of Ms. Browd's testimony and the state's cross-examination is that this rebuts her testimony that Linda Cruz was responsible. The person who is responsible is the person who has an antisocial personality, who has a borderline personality, and that's the defendant himself. That everything that Mrs. Cruz, the mother, tried to do for him was ineffective because of his personality disorder, not this neurodevelopmental disorder that the defense contends. And this goes all to that. And that is why this is fair game. This is cross-examination. I can show that she is an ineffective witness, that her testimony is not credible, and that it's rebutted by what we expect the evidence will show, and certainly would show in rebuttal to rebut the defense of the mitigation that they're using.
Just briefly in response, they would certainly be entitled to attack Ms. Browd during the time frame within which she said she knew the family. But she draws a line in the sand and says, after these dates, I had no contact with them whatsoever. And then for approximately 20 pages, she is asked, did you know this? No. Did you know this? No. Again, I didn't know anything after this date. Okay. Did you know this? No. Did you know this? No. Has ever seen this picture before? No. I don't know how that's impeachment of her knowledge of Linda Cruz and Nick Cruz during the time period she said she knew them. They're talking about a time frame when she specifically said she did not know them. So how that is relevant is beyond my comprehension. She knew them during a period of time that she said she knew them, and then it was literally their ties were totally cut. And that testimony is very clear in her deposition, in her perpetuated testimony.
Okay, that's why I think I need to read the deposition in whole, in its entirety, so that I can get a context.
Just a quick response to that. They may want to argue that, well, Linda Cruz was totally non-aggressive, wouldn't help her son get the help he needed in the years that she knew him. Oh, but suddenly, the years she doesn't know him, she becomes, super mom in getting him every kind of therapy. To the extent that she changed her opinion. I wasn't aware of all that. I must be wrong then. And that's, I should be able to impeach her as to what Linda Cruz did through her lifetime that shows that what she said about her not being aggressive, wouldn't go the extra mile, is not true. And that proves it wasn't true. Should we just handle the rest after you read?
No, I'm just gonna defer on this portion of cross-examination from page 158 to 177, and then if there are other parts within 158 to 177 that we can go over now, we can do that.
There's just objections 182 through the rest of the deposition.
I'm sorry?
There are additional objections from 182 to 190.
Okay, so let's go to those objections.
Yes, ma'am. I think beginning on page 181, line 19, Mr. Marcus asks, you're now aware the defendant would act out in class. Did you know that he would act out in class, that he would get kicked out of class? Ms. Browd says, I did not know. Mr. Marcus says, okay, if that is true, would you think that would be manipulation by him? And I objected as a speculation for an opinion on something Ms. Browd has stated she doesn't know anything about. Again, this would be a time frame during which Ms. Browd had no communication with either Linda Cruz or Nick Cruz. It pertains to his behavior at Westlake Middle School, which he didn't begin attending until after his mother's relationship with Ms. Browd had terminated. It is...
Looks like she didn't answer the question anyway.
Oh, is that right? I'm sorry. Let me look.
They're talking about getting kicked out of class. Is that true? If that's true, would you think that would be manipulation by him? Then you objected, and then Mr. Marcus moved on.
Okay, you're right.
So
I would just object to the question of would it be manipulation?
Mr. Marcus, do you have any objection to taking out that question since there was no answer given?
No, Your Honor.
Okay, so page 181, lines 24 and 25 will be redacted. And then page 182, lines 1 through 4 will be redacted.
Yes, ma'am.
Okay, what else?
Next objection, I think, is 183,
Yes, sir.
125.
And this one was, I think, simply an objection to the question being asked and answered.
Let me just read this really quickly.
Yes, ma'am.
Okay, so you're objecting to asked and answered, but I need you to show me where it was asked and answered. Please.
On 183, you're on line 17. Mr. Marcus asked, did you ever see him at the table or on the couch slumping to make himself look smaller or more sympathetic? Answered, no, Mr. Marcus, I've seen him slump on the couch just because being lazy, but not to make himself look smaller. Then Mr. Marcus asked, did you see him lower his head and slump his shoulders to make him look more sympathetic? At that point, I object to that second question. That is argued that is essentially the same as the previous question to which she answered no.
Okay, I'm going to overrule the objection. I think the question, I think you can based upon her answer, I think the question that Mr. Marcus was asking was different than what she initially answered. So based upon the objection being overruled, I'm going to ask that you redact page 183, line 25, page 184, lines 1, 2, 3, and 4. So it'll go from page 183, line 23, question, did you see him lower his head and slump his shoulders to make him look more sympathetic? And then the answer will be on page 184, line 5, when he got in trouble, he Mr. Secor, did you follow that?
Yes,
And
ma'am.
again, I'm physically,
Thank you.
I have a physical copy,
Thank you.
not a computer redacted copy, a physically redacted copy.
And then, may I move on, or?
Sure.
Okay. I think the final issue that I wanted to bring to the court's attention is on page 186.
Okay.
It was 184. You objected, I asked a question, line 9. Did you ever see him lower his chair to make him look smaller and more sympathetic? Answer, no. And you objected again to ask and answered. I don't think I asked that question before.
Okay. Thank you. I would just make the same objection to that as well that I've made to the previous question about him slumping his shoulders.
All right, I'm going to overrule the objection and ask that you redact page 184, lines, excuse me, lines 12 through 13. So also at the bottom of page 184, I think you all must have taken just a quick break. Why don't we take that part out? Page 184, line 22, where Mr. Secor says, Mr. Marcus, can I just have 30 seconds? Take that out. Line 24, line 25. This is on page 184. And then on page 185, lines 1 through 6 will come out. And then it'll start back up on line 8.
Your Honor, there's
Yes.
a series of objections now, 186 through 190.
Okay?
Again, dealing with her own son.
Okay, let me just read this quickly, okay? Okay.
Good.
Okay, I've read the last pages, which begin on 186, where the questioning begins of where the witness is questioned and asks, then answers about her own experience with her own child.
Yes, ma'am. Do you want to hear from me or from Mr. Marcus?
It doesn't matter. I assume you both want to tell me something.
Yeah, I'll be happy to go first.
Okay.
And this pertains back to an argument that we had sort of earlier on about the relevance of Ms. Brown's personal experience with her own son who has a developmental disorder. And our position, Your Honor, is that it is specifically relevant because the state is going to assert that Nick does not have a developmental disorder, and they're also going to assert that he got tons of services and that those services were adequate for somebody like him. And we are entitled to present evidence that a person receiving services does not necessarily mean that they are receiving the services that they need. A person can receive a lot of services without them being relevant to what is the person's condition. And Ms. Brown has personal experience with entities in Broward County, some of the same entities that provided services to the Cruz family, provided services to her family and her son, and she found them to be inadequate. And so it's relevant because she received services and her son did not get the help that he needed, and she had to really advocate to get him into a facility where his behavior could be controlled, where he could be properly treated. She had to do research herself. She had to have somebody from CPS advocate for her, and she described having to be very, very assertive to get her son the help she needed because these entities that she has personal experience with weren't able to identify or give her son the help that he needed, and he was totally out of control.
Her son was in foster care. These services she's mentioning, these are through Department of Children and Family Services. Sandy Pines, it's not an independent facility. That's through DCF. It's a lockdown facility. Once you've been in foster care for a certain amount of time and your behavior is so outrageous that you're basically a threat to yourself and others, and they commit you. A judge commits you.
I do know that based on Ms. Brown's testimony that is a lockdown facility. I agree with that, but he's been in various group homes that she has had to get him into, and she describes that in her testimony. And so for purposes of this case, it's important because this is somebody, again, that has experiences with Henderson Behavioral Health and other entities that are going to be the subject of testimony and dispute regarding whether or not those services were the type of services that Nicholas...
Let me just correct myself. I don't know for a fact that this young man was in foster care. In my experience in foster care as a judge, these are services that are only available once your child is declared abused, abandoned, or neglected, and they're in the foster care system. Whether or not at this time or back then, if they changed, I don't want to say something emphatically if I don't, but it seems to me she's talking about CPS and having him committed to a facility. I think these are foster care situations.
And I would have to look back exactly at my notes, but I think that that child may have been in her foster care custody prior to him actually adopting him. I seem to have a vague memory that may have been the sequence of events, but I can't tell you that for certainty. But I can tell you for certainty that she had experience with entities like Henderson, which are relevant because the Cruz family received services from Henderson. And a juror could very reasonably look at the magnitude of the records about the services that the Cruz family received and think to themselves logically, well, that's a ton of services, right? And so he was getting everything that he needed. And it's important that we go beyond that appearance of sufficient services to determine whether or not those services actually were adequate or were actually addressing the issue that Nicholas had. And Ms. Brown's testimony would be that in her experience, these very same entities did not identify what was wrong with her son or provide that family the support and services that they needed until she very aggressively advocated for her family and for her son. And then the reason it's relevant is because we conclude by pointing out to the fact, or Ms. Brown points out the fact that having known Linda so well for about, Linda Cruz that is, for about a maybe 25-year period from when they both lived in New York before they moved to Florida, and then their relationship deteriorated beginning in 2008 and totally ended in 2010, is that she says that the Linda Cruz that I know, Finney Brown, the Linda Cruz that I know would not have been able to do what I did to advocate for her kids. She just wasn't that type of a person. She wasn't aggressive. And you need to be in this system in order to get your family the help that you need. And so we would argue that that is very relevant mitigating evidence in this case. It's information that a juror could find very persuasive because, again, there's going to be a stark contrast between the state saying Nicholas got everything that he needed, couldn't have gotten any more, and us saying, but you have to look beyond that. You have to understand whether or not these entities have the resources and the personnel to identify what's wrong with somebody and get them the help that they need, and whether or not really being aggressive as a parent is something that's important. And I think, I'll leave it at that. And I would just incorporate the arguments that I made previously regarding, hang on just one second. I'm just being informed. Tell me this one. After Ms. Brown adopted her son, he was never in foster care. I was just informed that, so I just wanted to make sure that I stated that because I think I was obviously slightly unclear about that. But I would just incorporate the arguments I made regarding Florida Statute 921-141, Section 1, Barber versus State, Johnson versus State, and the federal cases of Tenard versus Dredke, Eddings versus Oklahoma, Lockett versus Ohio, and Sears versus Upton, for the principle that virtually no limit should be placed on the relevant mitigating evidence that a capital defendant may introduce concerning his own circumstances. Thank you.
Just my note our objection that Ms. Brown's son is not on trial. It's Mr. Cruz who's on trial. What his background or character or circumstances of his life are not relevant to Mr. Cruz's life. And it would be irrelevant, and to the extent that they are alleging negligence of Henderson or other services and trying to prove it through Mrs. Brown's son that he didn't receive everything he should have gotten, or his life was different, or whatever it is, they would not be relevant testimony. It's only what would be relevant is the defendant's background, character, or circumstances of the events.
Okay, I agree. I'm going to sustain the objection, and I'm going to rule that starting on page 186, lines 23, through and including page 190, lines 23 should be redacted. Okay, so there's two remaining issues with regard to the testimony of Ms. Finney Browd. There is the page 140 through 156 that the state wants an opportunity to review, and then you all are going to let me know by tomorrow what your position is, whether or not you still believe that should be admissible. Then there is the remaining issue of page 158 through 177, where the state is arguing that this is admissible cross-examination, and the defense is arguing that it is not relevant for a number of reasons, and that it's hearsay, that I am going to defer ruling on, and after I read this deposition in its entirety, I'll have a ruling either today or tomorrow on 158 through 176.
One of the things, Your Honor, may I request is that you just ruled that it would be redacted through page 190, line 23. Is that correct?
Yes.
And I would just ask that the remainder of the deposition also be redacted.
Sure. It's just, is there anything else before we conclude? So then it would, I guess the testimony would stop on page 186, line 22.
Yes, ma'am.
State, is there any objection?
No, Your Honor.
Okay. Okay, now the remaining issue for today is the previous motion that was filed to strike the agreed order striking Dr. Andrew Ackerman and request an agreement by the state and the defense that the statement taken on August 11th, 2022 be filed under seal as work product. Is there anyone from the media that is here that wants to be heard on this issue?
Yes, ma'am.
I'm sorry to keep you waiting. Come on up.
May I go?
Sure.
My name is Danielle Abrat. I'm in for Dana McElroy.
What is your last name?
Abrat, A-B-R-A-T-T.
Abrat. Okay, just a quick question for the lawyers before the other lawyers before I get to you. Why would this, if it's a statement, it's a sworn statement, why would it be filed anyway? If the witness is not testifying, I'm just asking.
Judge, initially it went out.
I mean, if you take a statement of a witness and the witness doesn't testify, do you file it?
Well, originally, Judge, it did go out in discovery originally, and then it was attached
Okay.
to a state's notice that was filed the other day.
Okay.
Notice to the court.
Okay, all right. So the parties want to seal the statement, arguing that it is work product.
Your Honor, first of all, our position is, obviously we are against any sealing. We believe that the parties cannot unilaterally agree to seal any motions. I'm happy to give you my argument on that, but since it is a defense motion, I don't know whether you would want them to actually argue their motion first, and I'm happy to respond to their arguments, or if you'd like me to just present my argument first.
Well, actually, I think both sides, the state and the defense, are agreeing that if I'm not mistaken, that the statement should be sealed. No?
Just agreed.
You're in agreement.
No, they wanted to seal it. It's okay. We agree.
You're not objecting.
No.
Okay. Does the defense want to make argument?
Judge, our understanding was, at least from yesterday, that we were going to hear from the media, and we have our motion. I'm happy to make argument if Your Honor wants to hear it.
I'll hear whatever you all want to present. So, counsel, why don't you go ahead then?
Okay, Your Honor. So essentially, the definition of work product is that it's confidential. If in the defense motion they stated that it is the defense's work product, but it is now in the hands of the opposing party, the state. So by definition, it's no longer confidential. There's no purpose fulfilled by keeping that a secret. Since the opposing party, the state has whatever their mental impressions are, or whatever their strategy is that is supposedly protected by this work product privilege. As this court knows, there is a presumption of openness. This document is purportedly attached to the notice that was filed with the court, and any sealing of records is governed by the Rules of Judicial Administration, Rule 2.420. That rule specifically codifies the tests provided and laid out by the Florida Supreme Court in the Lewis and Barron cases, which of course requires the party seeking closure to establish the three-pronged test, which the defense has not done. I understand that the state is not objecting, but that doesn't ease or diminish the defense's burden to prove that sealing of these records is necessary to protect any kind of work product or attorney-client privilege, which again we maintain is non-existent here because the state has it. So that's essentially our argument on work product. They did also argue that there is private medical information in the statement as well. The Florida Supreme Court case in Barron is right on point that the test for closure of records based on a privacy right is that the privacy right has to be not inherently involved in the proceeding. Any medical information, as is made clear just from all the argument today, is very clearly inherently part of the proceeding. And as Barron stated, which involves medical reports, it said, medical reports in history are no longer protected when the medical condition becomes an integral part of the proceeding, particularly when the condition is asserted as an issue by the party seeking closure. So Barron very clearly shows that any privacy rights cannot be used as a basis to seal records. And we maintain here that that's equally applicable, and the statement should not be sealed.
Okay.
Judge, if I could just have a moment to confer.
Okay.
Thank you. So part of what the media is missing here is that this statement was taken over our objection. We were not present in order to assert our work product privilege. So this statement was taken, the defense was not present. The statement's not going to be used at trial as Your Honor has the stipulation. We are arguing that our work product privilege was not waived because we were not present in order to make that argument at the Zoom pretrial where the statement was taken.
But how can it be your work product if you weren't even there?
No, our work product is what the doctor was discussing. What the doctor states in that statement contains work product.
Do you want to say anything else?
Sure, Your Honor, regardless of whether it was proper for the state to take the statement, I think it's irrelevant to just the question of whether the public should have access to records, to judicial records. This is a statement that was filed as an attachment to a notice filed by the state, and it is presumably open. It is a judicial record. Whether it was proper for them to take the statement in the first place, I think is a separate question. Whether it's admissible, whether the witness will be testifying, all separate questions. If it's filed in the court file, it's presumptively open, and I do not believe that the defense is going to burden under Lewis and Barron of showing that, one, that the privilege is applicable, and two, that closure is necessary under Lewis and Barron.
Okay. I'm going to take the matter under advisement, and I'll have an order today or tomorrow, okay?
Thank you, I appreciate it.
Where are you from?
South Africa.
Oh, you have one of those accents that's so pretty, but you can't exactly tell where it's from.
Thank you. I've been here for a long time, so it's watered down a little bit.
It makes you sound very smart.
Thank you. Thank you, Your Honor.
Right? Like Alexia.
That's right.
Judge, I have one other matter, if I may.
Okay.
The defense is going to be calling witnesses that are going to testify via Zoom.
Okay.
And we have a suggestion on how maybe we can address the as-new issue, the confrontation issue that came up. And I think Ms. McCann handled that in victim impact for one of the victim impact witnesses. What the defense is requesting that outside the presence of the jury, the witness will be on Zoom, and Your Honor can inquire the witness and ask them, are you able to see the defendant? And then ask Mr. Cruz, are you able to see the witness? Yes, yes. We bring the jury in and have the testimony. I think the state is fine with that, and we're going to test everything later today, hopefully, to ensure that even if we're sharing documents on the screen, that Mr. Cruz and the witness are still able to see each other throughout the entire testimony.
Okay, but I think you guys should ask those questions.
I think the state wants you to ask it. I think we should ask it. I am fine with it. Either way. We're fine with it either way.
It doesn't matter, Your Honor, as long as the questions are asked and as long as the witness and the defendant can both see each other the whole time, and if there are documents being up there for examination, that they don't interfere at all with both the witness and the defendant being visibly able to see each other on the screen, because that will be reversible error.
Right. Okay, so why don't you all come up with a little list of what you want me to ask each witness before they start? Good idea?
Okay. I mean, if the state's fine with it, we'll ask the questions. It's our witness. We don't have a problem asking the questions.
Now that I think about it, it's probably better for me to do it so that I can also make a finding that the witness can see Mr. Cruz can see the witness, and so on and so forth.
Yes, Your Honor.
Yeah.
But does this need to be, do we have to stop before every witness, take the jury out and do this?
Yes.
Yes, but Judge, I don't believe if there are back-to-back witnesses, it's not going to be often. It's not going to be back-to-back witnesses on Zoom. It's not like all of our witnesses are via Zoom.
Okay.
Okay, so you want me to come up with questions and present them to you and the state?
That would be good.
Okay, no problem.
Because Zoom is not my favorite.
Sure.
Something always. Also, with the whole swearing in, you all see, Ms. Bashman, I don't know if you were in my division during COVID, but I had a rule that the lawyer, whatever side was calling a witness, had to have a notary present to swear them in. And you see the hearing that we had, it was a perfect example of why I used to do that, because you see he's trying to show me the driver's license and there's some kind of blurring effect, and then I can't see it. And imagine during COVID to have 200 hearings and have to do that. So if you could at least familiarize, let the witness know I have to see a valid ID and familiarize them beforehand,
Sure.
that would be helpful.
Yeah, we received an email from Nicole, your J, and she informed us to ensure that we talk to our witnesses about learning the background, having a clear picture of that.
Whatever it is that you have to do to make it so that I can see it, so that I don't have to spend, sometimes it adds 15 minutes when I have to keep saying, okay, can you go outside, can you do better lighting, and so on and so forth.
We are pre-trying our witnesses.
Sure, and if you would prefer to have a notary from your office swear them in, I can walk them through it. You want me to do it? That's fine.
You're fine with having you do it. We'll let them know, and we know what the issue is, so we'll tell them to fix that. And show that.
I wonder if sending me a copy of the driver's license.
That's actually somebody that just texted me. Would you like a photocopy of the identification ahead of time?
That might be very helpful. They could hopefully have it on them as well, so that I can see the original, but I can reference the copy.
That's perfectly fine with us. We can have them.
State, is there an objection to that procedure?
No objection.
Okay. Okay, is there anything else for today?
Just one quick thing. I know we all have more to do than we can possibly handle at one time, and I obviously want the court to take all the time it needs. I just would politely remind you that we have to do the redactions of the video, and so just as soon as you have time, we
Absolutely. I intend to do that, work on that right after court is in recess. And there's somebody from the sheriff's office here, which I anticipated.
Yes.
Sergeant,
Yes.
how are you?
Good, Your Honor. I just wanted to clarify that the order that's written, it goes against our policy as it relates to inmates that are here as witnesses. We are not allowed to accept court clothes that specifically addresses that kind of policy.
So, you all are going to have to take it up with BSO Legal if you want to pursue this request. But the sheriff's office doesn't dress, they have it in their policy that they will dress a defendant or an accused for court, but not a witness. I suspected that might be the case because I've never seen it done before, but thank you for letting me know.
Yes, ma'am.
And I'm letting you all know. Okay?
Thank you, Your Honor.
Okay, thank you. We're in recess.